You know, usually when you think about like someone getting fired, you picture something incredibly straightforward, a dramatic, undeniable event.
Right, like someone getting caught stealing from the cash register or something.
Exactly. Or maybe they start screaming at a customer in the middle of a store. It's a clear line, you crossed it, so you're out.
Yeah, but then you step into the actual day-to-day reality of workplace relations. And
And suddenly that clear line just completely vanishes into this, well, this murky landscape of human behavior. So have you ever wondered where the exact legal line is drawn between harmless workplace banter and an actual fireable offense?
it's a huge gray area for most people.
Because what happens when a boss fires someone over fart cranks? Or like making Michael Jackson noises?
I mean, it sounds absurd on the surface, right? But these are real cases,
Hmm.
and they carry massive financial and professional consequences.
Yeah, no kidding.
Tribunals deal with these situations constantly, and the legal tests they apply are far more rigorous than most people realize.
Okay, let's unpack this. Today, we are taking a deep dive into the fascinating, highly nuanced, and sometimes downright bizarre world of workplace relations.
It really is a wild world once you start digging.
It really is. And our source material today comes from the Australian Workplace Discrimination Representatives, or AWDR. They are a firm of non-lawyer workplace relations specialists, and they have like over 30 years of experience under their belt.
Yep, they really know this space inside and out.
We're specifically analyzing their May 2026 breakdown of 3 shocking, unfair dismissal cases. Our mission today is to uncover the legal mechanics of how tribunals actually decide who gets fired fairly and, well, who gets a massive payout.
What's fascinating here is that it really is a mechanical process when you look under the hood.
Right.
It's not just about who was right and who was wrong on some moral level, you know. The jurisprudence here relies on procedure, context, safety legislation, and risk mitigation.
I want to start by looking at a case where an employee thought they were just using standard blue-collar language. But the tribunal saw a literal danger to human life.
Ah, yes, the Jetstar case.
Yeah, this takes us to the 2023 Fair Work Commission case involving a guy named Nathan Woods. He was a maintenance engineer for Jetstar Airways, a guy with a 14-year tenure. You would assume a veteran like that knows the operational boundaries of an aircraft hangar.
You'd think so, right? But his downfall actually started when a subordinate accused him of bullying, and that triggered a formal internal investigation.
And what Jetstar uncovered during that process was severe.
Very severe. It began with racial remarks. During the COVID lockdowns, Woods claimed that residents of Fairfield were responsible for spreading the virus. And this is according to the tribunal records. He said they pretend they cannot speak English.
Oh, wow. And when a colleague of Chinese descent challenged him on that, Woods doubled down. He stated, "I live there. They're Asians. I know what they're like."
Just completely unacceptable.
He also told a colleague of Filipino descent that his smile reminded him of the Bali bomber, referencing the convicted terrorist from the 2002 attacks.
Right, and the Fair Work Commission found the Fairfield comments to be a clear breach of discrimination policies, stereotyping an entire community.
And while they didn't technically classify the Bali bomber comment as racially motivated in a strict legal sense, they officially labeled it as, quote, unflattering and weird, and a clear breach of respect.
Yeah, unflattering's putting it mildly. And the profanity he used was also on another level entirely. It was extreme. And crucially, it was directed aggressively at subordinates.
Give us an example.
So in one specific instance, a junior staff member asked a technical question about aircraft parts. Woods literally waited for the junior guy to leave the room and then turned to the remaining staff and called him a dumb cunt.
Wow. Over a technical question.
Yeah, and he used that exact same severe profanity to describe another colleague who had simply asked for permission to use a Qantas hangar. So Jetstar summarily fired him.
Okay, but in his unfair dismissal claim, Woods used a defense that I think a lot of people have heard before. He argued that his language was somewhat colorful, but it was ultimately just standard blue-collar banter.
Right, the old banter defense.
He claimed this was the established custom and practice of the environment. But I want to push back on behalf of you listening. Wait, isn't a maintenance hangar historically a rough-and-tumble environment?
Historically, sure.
But trying to use the blue-collar banter defense today is like trying to use a 1990s rulebook to play a 2020s game. Why exactly did the tribunal reject this defense so completely?
What's fascinating here is how the Fair Work Commission dissected that exact argument by moving the framework away from, like, hurt feelings and into the realm of occupational health and safety.
Oh, interesting. So it becomes a safety issue.
Exactly. The legal mechanic they applied focused on psychological safety as a direct precursor to physical safety. I mean, we're talking about aviation maintenance here.
High stakes.
Very high stakes. If you allow an environment where targeted verbal abuse is the accepted norm, you actively discourage junior engineers from asking vital technical questions.
Right. If a junior mechanic is terrified of being called a horrific name by his supervisor just for asking how a specific aircraft part works, they might just stay silent.
Exactly. And if they stay silent, maintenance errors occur. And if maintenance errors occur, planes crash.
Wow. That reframes the entire concept of a toxic workplace. It's not just a bad vibe, it's a measurable operational hazard.
Precisely. And AWDR's analysis actually highlights a very specific rule the Commission applies here regarding profanity.
Oh, right. The difference between general and targeted swearing.
Yeah. The Commission might tolerate general swearing if it's part of the common culture, like dropping a wrench and swearing at the wrench.
That's just an exclamation.
Right. But targeted denigration, aimed at a person to harshly belittle them, is viewed as an aggressive assertion of dominance. And that is a direct breach of health and safety legislation.
So the context matters, but the target and the intent matter way more.
Absolutely. But that brings us to an incredible twist in this Jetstar case that really tests the boundaries of employment law.
Yes, the subordinate who initially accused Woods of bullying, a guy named Christian Troyak.
Right. It turns out Troyak's own behavior in that same hangar was arguably even more extreme than Woods.
This is the part that just completely short-circuited my brain. Troyak was accused of regularly displaying an erection and rubbing it over his pants in front of colleagues.
Yeah, it gets wild.
He was accused of frequently passing wind in front of staff and making gas chamber jokes to a Jewish colleague. Yet Troyak kept his job with a final warning, and Woods got fired.
It sounds totally backwards, I know.
As an outsider, I really struggle with this outcome. It feels incredibly manipulative to say that a guy who exposes himself gets to keep his job, while the guy who swears gets fired. Is the tribunal actually judging sincerity or just checking some legal liability box?
That is a phenomenal question. If we connect this to the bigger picture of employment law, the tribunal's decision rests on two fundamental legal pillars. First, a supervisor's duty of care. And second, the concept of contrition as a metric for rehabilitation.
Okay, let's break those down.
Well, first, Woods was Troyak's supervisor. He knew about this egregious conduct, but actively failed to report it until he himself was under investigation.
So he just sat on the information.
Exactly. The Commission views that not just as hypocrisy, but as a severe breach of his professional duty to maintain a safe workplace. He weaponized the information rather than managing it.
And what about the contrition piece? Because reading through the AWDR source material, contrition seems to be the absolute golden word in every single one of these tribunal documents.
It really is. In the eyes of a tribunal, contrition is the dividing line between a salvageable employee and an unbearable risk.
How so?
Well, when Troyak was confronted with his horrific behavior by HR, he was entirely honest. He showed genuine remorse, and he accepted full responsibility without caveat. He was contrite.
And
Woods, conversely, was described by the Fair Work Commission as disingenuous and obfuscatory. During his investigation, he refuted the basic premise of questions. He deflected blame onto others. He minimized his actions.
So it's the difference between saying, I messed up, I recognize the damage I caused, and I need to change, versus everyone else is too sensitive and you're all out to get me.
Precisely. Contrition proves to an employer, and subsequently to a tribunal, that an employee can be rehabilitated. If you admit fault, the company can deploy training, apply a final warning, and legally protect themselves from future liability.
Because they took corrective action on an employee willing to correct themselves.
Right. But a complete lack of remorse means the employment relationship is, in legal terms, irreparably damaged.
To really hammer home how critical this mechanism of remorse is, we should look at the 2025 case out of the UK involving two London police officers.
Oh, this one is rough.
If you want to see what a legally fatal lack of contrition looks like, this is the textbook example. This involves Officer Wayne Sansom and Officer Ben Jeffries. Both were fired, and both were permanently barred from the Metropolitan Police.
Let's start with Sansom.
Yeah, so Sansom approaches a female officer and asks her to, quote, pull his finger. When she declines, he turns his back, stands on his toes, and passes wind directly in her face from a distance of about 10 to 15 centimeters.
Unbelievable.
Yeah.
And at his unfair dismissal hearing, Sansom admitted to making the verbal remark but flatly denied actually breaking wind.
Just denying physical reality.
Right. The employment tribunal applied the balance of probabilities test and found the physical act was proven, calling his attempt at humor misplaced and inappropriate.
Mhm.
But the tribunal also uncovered a culture of discrimination that ran much deeper than juvenile pranks.
Yeah, it wasn't just fart jokes.
No, Sanson was heard using racist slurs against Romanians. When a female colleague pointed out this bias, he told her, "That's not true, I would put my DK in you."
Mm.
He also called her a lesbian as a derogatory insult.
And we are impartially reporting the tribunal's findings here, right? And those findings depict a deeply hostile work environment. And his colleague, Ben Jeffries, operated in the exact same manner.
Yeah, Jeffries was just as bad.
During a protest, a female officer handed Jeffries her phone so he could use Apple Pay to buy water for the team. When she got her phone back, the camera app was open, and sitting in her photo gallery was a fresh photograph of Jeffries' testicles.
Just why?
Right. And when she confronted him about this, Jeffries showed zero remorse. At the employment tribunal, it was revealed he literally asked her, "Why are you getting offended? It's just a picture of my balls."
It is staggering.
Acting like Jeffries during a formal investigation is like getting pulled over for speeding and offering the police officer a sip of your beer. It just proves you fundamentally do not comprehend the rules of the society you are operating in.
That is a perfect illustration of what tribunals call a lack of insight. And just to continue impartially reporting on the tribunal's further findings regarding Jeffries, he was also found to have targeted a black female colleague with racially motivated mockery.
Right.
The tribunal found he held a door shut, told her he thought she was going to start screaming Black Lives Matter, and mimicked punching her while chanting the movement's name.
So you have a combination of blatant harassment, zero self-awareness, and absolute denial.
Which makes reinstatement a legal impossibility. I mean, if an employee asks why someone is offended by an unsolicited photo of genitals, they're demonstrating that no amount of HR training will fix their judgment.
They're beyond a seminar.
Exactly. A tribunal cannot order an employer to reinstate a worker who poses an active, unmanageable liability to the company and their colleagues. The trust is gone, and legally, the dismissal is entirely fair.
So we've established what happens when the employee completely torpedoes their own case through denial and a lack of self-awareness. But let's look at the other side of the coin.
The employer's responsibility.
Yes. What happens when an employee acts bizarrely, but the employer fumbles the investigation? Because the AWDR sources highlight a case where a fired employee actually won. And it is a masterclass in the legal requirement of procedural fairness.
This is such an interesting pivot. This takes us to an August 2025 case involving a UK cooperative group warehouse worker named Lucas Zawadzki. He had been employed at the company for over a decade.
A long time. A colleague lodged a complaint stating that for roughly 2 years, Zawadzki had been making highly inappropriate noises on the warehouse floor, specifically high-pitched hee-hee sounds mimicking Michael Jackson.
2 years of this.
Yeah, and what another staff member formally described during the investigation as stupid orgasm noises. Now, Zawadzki was also accused by a black colleague of making racist monkey noises, which obviously elevates this from juvenile annoyance to a severe allegation of racial discrimination.
It does, and that elevation requires a corresponding elevation in the standard of proof. During the internal investigation, Zawadzki admitted to the Michael Jackson noises and the grunting, which he openly acknowledged could be described as orgasmic and inappropriate for the workplace. But he strictly and consistently denied making any racist monkey noises.
He drew a hard line there.
He did. He stated he had no intention of bullying anyone and noted the colleague had never once mentioned being offended in their long history of working together. Crucially, when the employer reviewed the warehouse CCTV footage, they could not corroborate the claim that the monkey noises had occurred or been witnessed by any other staff member.
Despite the lack of corroborating proof on the racist allegation, the cooperative group fired him for serious misconduct. They cited the Michael Jackson and orgasm noises, stating it violated their zero-tolerance policy on bullying and harassment. Here's where it gets really interesting. Zawadzki took this to an employment tribunal for unfair dismissal, and the tribunal ruled that his firing was unfair. He won the case.
He actually did win. The tribunal formally slammed his behavior as juvenile, but they found the dismissal itself was procedurally flawed and therefore legally unfair.
I feel like we need a really strong analogy to clarify this concept of procedural fairness for you listening. Think of procedural fairness like the chain of custody in a murder trial.
Oh, that's a good way to look at it.
You can have the murder weapon with the suspect's fingerprints all over it, but if the police didn't get a legal warrant to search the house, the evidence gets thrown out. Zawadzki was definitely guilty of making the inappropriate noises, but the employer didn't have their legal warrant in order, meaning a clear, documented, and properly executed disciplinary policy. Why exactly did the employer lose this?
Because the legal mechanic of a zero-tolerance policy is entirely void if employers don't actively train staff on it and enforce progressive discipline.
So you can't just say zero tolerance after the fact.
Exactly. The tribunal looked at Zawadzki's 10-year employment history. In a decade, he had never received a single formal warning. Although the company claimed they were relying on a strict zero-tolerance policy, the investigation revealed Zawadzki had never actually been provided a physical or digital copy of it,
Wow.
nor had he received any mandated training on what it entailed.
So legally, he couldn't have reasonably known that his juvenile behavior, which had been tolerated for 2 years, would suddenly lead to immediate summary termination without a single prior warning to correct his behavior.
Exactly. The employer bypassed the entire mechanism of progressive discipline. Plus, the tribunal noted there was no solid evidence for the racist noises. In employment law, when you accuse someone of serious misconduct, the burden of proof relies on solid evidence, not just hearsay or uncorroborated allegations.
That makes sense.
Furthermore, there was a complete lack of transparency regarding who at the cooperative group actually authorized the firing. The internal process was just a structural mess.
Because the employer failed so spectacularly on procedural fairness, Zawadzki was awarded $8,541, which translates to around 16,000 Australian dollars.
Yeah.
But just like the murder trial analogy where the guilty guy still has to live with his actions, the tribunal actually reduced Zawadzki's payout by 50% specifically because of his culpable and blameworthy conduct.
Yes, the financial penalty.
I'd love to know how they calculate that. It's essentially saying, you won because they broke the rules, but we are docking your pay because you are still responsible for the situation. It's like winning a marathon, but the judges dock half your prize money because you spent the whole race taunting the other runners.
I love that analogy. That is a legal principle called contributory fault. The tribunal mathematically assesses how much the employee's own culpable conduct contributed to their dismissal, regardless of the employer's procedural failures.
Fascinating.
By reducing the payout by 50%, the tribunal is sending a dual message. Employers must adhere to immaculate termination procedures, but employees will still pay a literal financial price for acting like a juvenile.
So nobody gets off entirely scot-free.
Right. If an employer skips steps, they open themselves up to massive liability, even if the employee was acting terribly.
So we've walked through these intense legal breakdowns, but let's pivot to your daily life. What is the practical toolkit here? If you ever find yourself facing a toxic workplace culture or a sudden, unexplained termination, how do you navigate the mechanics of the law?
It's vital to know.
The AWDR analysis emphasizes a critical point. Employees are often completely unaware of their baseline rights under the Fair Work Act and equal opportunity laws.
And that lack of fundamental awareness is exactly what allows unfair dismissals to go unchallenged. AWDR operates as workplace relations specialists. They analyze the fair work system and provide strategic guidance across a range of complex issues.
Things like unfair dismissal and sexual harassment.
Yes, as well as general protection disputes, non-genuine redundancy, and adverse action.
Yeah.
Their breakdowns show that understanding the strict mechanics of the law is your only real defense.
So, what does this all mean for you? If you feel you're being targeted or unfairly managed out of a business, what are the golden rules you need to lock into your brain right now?
The primary non-negotiable rule is understanding that time is your biggest enemy. Under the Fair Work Act, there is a strict 21-day deadline to lodge most claims.
Just 21 days.
Yes. It is a rigid jurisdictional barrier. If you sit around for a month wondering what to do or waiting for HR to return your emails, you will lose your legal window to act entirely.
Wow, that is a tight turnaround. What else?
The second rule is absolute documentation. If you're experiencing a toxic workplace or bullying, keep fastidious records, dates, times, witnesses. Write it all down.
You need a paper trail.
Exactly. And finally, understand the specific legal definitions of your situation. For example, knowing the distinct difference between a genuine redundancy, where a specific operational role simply isn't needed anymore, and an unfair dismissal that an employer has fraudulently dressed up as a redundancy just to avoid paying you out.
It's about knowing the exact rules of the game so you don't get played off the board. We've covered a massive amount of ground today.
We really have.
We started inside a Jetstar maintenance hangar, learning that targeted profanity isn't just bad manners, it's a breach of occupational health and safety disguised as blue-collar banter.
A huge shift in perspective.
Definitely. Then we saw how genuine contrition saved one worker's job by proving rehabilitation was possible, while a total lack of remorse doomed two London police officers because it irreparably destroyed the employment trust.
And then the procedure piece.
Right. We saw how an employer's failure to provide warnings and policy training led to a massive payout for an employee making Michael Jackson noises, proving that procedure dictates everything.
It really does. The law doesn't care about your feelings. It cares about the documented steps you took. And this raises an important question to leave you with, which stems from a brief mention in the AWDR articles regarding flexible working arrangements in 2025.
Oh, the work from home era.
With remote work fundamentally reshaping the Australian corporate landscape, how do these complex legal rules of banter, misconduct, and contrition translate to a purely digital space?
Oh, that is a fascinating frontier.
Right. I mean, if someone sends a questionable, culturally insensitive GIF on Slack or makes a weird noise on an unmuted Zoom call, is that the new legal battleground for unfair dismissal?
It has to be, right?
The physical boundaries of the office have disappeared, but the legislative requirement for employers to maintain a safe, respectful environment hasn't changed one bit. The tribunals are going to have to figure out how to police the digital hallway. It is something to keep a very close eye on during your next remote team meeting.
That is both a terrifying and excellent point. It brings us right back to where we started. The line between a bad joke and a fireable offense is incredibly murky, and whether it's a fart prank in a physical office or a weird meme in a corporate chat box, the legal mechanics are always watching, and the procedural clock is always ticking. Thank you so much for joining us on this deep dive. Stay curious, document everything, and always stay critically aware of your rights in the workplace.